The last has not been heard about the leader of the proscribed indigenous people of Biafra, IPOB, Nnamdi Kanu, as the Nigerian government has indicated that it will not release him despite Thursday's Court of Appeal judgment, which quashed the charges against him based on what the court described as illegal rendition. Instead of releasing the IPOB leader as ordered by the court, the government says it is reviewing its legal options and could institute other charges against him. Now, the Attorney General of the Federation and Minister of Justice, Abubakar Malami, the government's first official reaction said the federal government's decision on the case will be announced to the public after a review of available legal options. In a statement, Malami said the initial case filed against Kanu before he absconded out of Nigeria subsists, with many agitations for the appeal court order to be obeyed. What are the implications of this? Well, to unbundle this, a lawyer to the embattled Nnamdi Kanu, leader of the proscribed indigenous people of Biafra, Ifeanyi Ejiofor, joins me now. Thank you so much, Barrister Ejiofor, for joining us.
How are you?
Yeah.
It's a pleasure being on your platform.
Thank you so much. And let's talk about this latest development, the federal government saying that your client still has a lot to answer and that this case is only on the rendition. I want to first ask, did the federal government at any point in time tell the court how Nnamdi Kanu managed to get back to Nigeria?
The point is that they were unable to respond to the issues of the borders on his abduction in Kenya and consequent external rendition to Nigeria when we raised that issue as forming part of our ground for objecting to the revision of the court intended suit. They didn't respond to it at the High Court, before the court below, even at the Court of Appeal, they didn't address that issue. But the point is that I don't think, with due respect to the Attorney General of the Federation, I don't think he is on a good standing to react to the judgment of the court because he was not in court on that day the judgment was delivered. The court held the abduction because in the language of the court is abduction, it's no longer arrest.
No longer extraordinary rendition,
So
using that big grammatical
The court concurred
phrase
with us that it's an abduction. So what happened in Kenya was an abduction of Nnamdi Kanu and consequent extraordinary rendition to Nigeria. That has been settled. So and on that basis, several international laws, protocols and conventions to which Nigeria is a state party to, we are flouted with impunity. And as such, there's no charge, there's no trial that can be conducted. As far as that violation has been established. So, because it cannot place something on nothing and expect it to stand.
Yeah, but there was a court case before Nnamdi Kanu left the country, which is what the AGF is saying.
Let me address that point. You see, if you are talking about the charge, we're talking about one charge. We have only one charge in court. That is charge. The charge number FHC/ABJ/CR/383/2015. That's only one charge. An objection raised to this, the competence of the charge, when amendment was effected from 5-count charge to 7-count charge, from 7-count charge to 15-count charge, the court constantly struck out 8, remaining 10, 7, and we went on appeal. Appeal court on the 13th of October 2022 struck out the remaining count charge. So, in the eyes of the law, there's no that charge pending before the court. And now remember, don't forget, that the court proceeded to buy further proceedings against Nnamdi Kanu, for an indictment on him. So even if they want to file another charge against Nnamdi Kanu, it cannot go on. It cannot go on.
Why?
Because court has to inquire, as rightly held by the Court of Appeal, the court failed to inquire into the manner in which he was abducted in Kenya.
Yeah, but apart from that abduction, you have said that those other cases, the initial case filed in 2015 was gone. But doesn't the federal government have the right, if it has available information, to file fresh charges?
They cannot file. Because
what they had said, that, I mean, all those terrorism charges and all those things, if they had fresh information, shouldn't they be able to try him as a Nnamdi Kanu?
No, the court had barred them by virtue of what transpired in Kenya and his rendition to Nigeria, illegal rendition to Nigeria. The court had barred further proceedings, criminal proceedings against Nnamdi Kanu. That was why the court declared that Nnamdi Kanu should be released immediately and unconditionally.
Yeah, and he hasn't been released. I mean, I'm interested in knowing what you have been doing since Thursday, because your client was supposed to have been handed to you right there in the court, but we didn't see that happening.
We are going to serve them formally on Monday, because the judgment of the court will be out on Monday morning. We'll serve them on Monday, and we'll have our client back, settled.
You think he will be given to you?
Sure. Because the point is that even if they are challenging the order of the Court of Appeal before the Supreme Court, even if they are challenging the judgment of the Court of Appeal, the authority settled that you must, first of all, it cannot be in content of order of Court of Appeal at the point you are going to Supreme Court. You must obey that order first of all before going to Supreme Court. So they must obey the order made by the Court of Appeal on 13th of October 2022 by releasing him unconditionally.
Well, so, if I for you and I know what has been happening with the DSS, what if they release him to you and then they just wait for him at the gate again, like it happened in previous times? What will happen?
We'll get that bridge crossing. The point also, let me just clarify this. Of course, you understand what happened in his house on the 14th of September 2017 is a matter of common knowledge, which are fully aware about how his premises was invaded by Nigerian soldiers. Now 35 persons has been established, killed by Nigerian soldiers in an attempt to eliminate him.
Was it to eliminate him or to arrest him? Because the government said he had lots of questions to answer. He was free, given bail, and he defaulted on the bail.
Now, let me tell you something. Let me just
including putting a serving senator in trouble who stood surety for him.
Let me clarify you. Maybe let's within the public space now. Let us hit the nail on the head. Nnamdi Kanu was granted bail on April 17, 2017. And the matter was adjourned for trial to October 17th. Now, Nnamdi has passed through pre-trial conference before getting set for the trial coming up on 17th of October. Now, assuming without considering to the fact that in the course of enjoying this bail granted him by the Federal High Court, you and me and you know, you're not a lawyer, but I don't know whether you're a lawyer, but you should understand what I'm talking about. Then in the course of enjoying this bail granted by the Federal High Court and committed another offense, the law allows them, you don't need to go to his house and look for him. You wait. Let him come to court on October 17th. If he's in court, you can still arrest him. Now they took the word to his house, and in consequence thereof, killed over 31 persons in his premises. Now, if somebody is coming here to arrest Soma, assuming they are investigating you for being involved in any kind of offense, commission of any offense, and they came here and probably see some people and decided to start killing innocent unarmed citizens. These guys were not armed. Then will you classify that as an arrest? That's not an arrest. The essence is to eliminate him.
Okay, that's in your own words. Well, as we try to round off this conversation, Ifeanyi Ejiofor, I read the statement by Bruce Fine, one of the lawyers, his international lawyer, where he was saying that, look, if Abubakar Malami goes ahead to this, then he also has to be cautious because the ICC is there for him, waiting for him when he leaves government, because it looks like he's trying to deprive Nnamdi Kanu of his fundamental human rights. What do you make of that?
Don't forget that on June 20th, 2022, United Nations Working Group on Arbitrary Detention issued a communication to the Nigerian government directing them to release Nnamdi Kanu conditionally, and also directing them to pay him to compensate him adequately for gross violation of his right. They have not responded to this communication till date. I know what it means. Before the letter pronouncement by the Court of Appeal, that was on 13th of October 2022. So already, by exposing this country, because I believe that AG Federation was instrumental to what happened in Kenya. And it's also very important to point out that even in Kenya, because we have an action we file against the federal government in Kenya, in the affidavit they filed before the court in Kenya, the Kenya government admitted in their processes they filed in court that Nnamdi Kanu was legally admitted in their country sometime in May. But as we speak today, they are from the process they filed in court and in the eyes of the law, like Kenyan law, Nnamdi is still there.
Okay. And you haven't answered that. I mean, what would happen in this case?
No, is
Abubakar Malami going to face
by authority of the Supreme Court decision against the Lagos State government, and also recent decision of the Supreme Court on against FRN? The federal government has the right. They can exercise the constitutional right for appeal, probably challenge judgment of the Court of Appeal before the Supreme Court. But they cannot apply for stay against that order of Court of Appeal. It's a declaratory order. So first of all, before they take further steps, they will amend that order. Unless they are inviting anarchy. Because any attempt to disobey that order, we resort to something that one cannot expect. There will be consequences to that effect.
Well, you're talking about the state here. And of course, you know the powers of the state.
On 29th of June, without us being in court to detain him before the SSL detention facility. We were not in court that day. And that order was obeyed. Ordinarily, we have been remanded in prison custody.
Yeah, but we know the federal government has not been obeying previous court orders.
They will have no option. They must obey this one.
You're hopeful of having your client on Monday?
The Court of Appeal the Court of Appeal is not requesting them. It's an order of the court.
All right.
It's a positive order of court. They must obey it.
All right. How about those who are reading political meanings to it? That is because of the 2023 election. That this looks like an underhand deal by both the federal government and your client, Nnamdi Kanu, for the 2023 polls.
Let me clarify this. Thankfully, His Lordship Honorable Justice Nikitobi, said it openly in open court. At the point was the different judgment that their judgment has nothing to do with any political undertone or any formal political. They're not even influenced by what they are reading over the social media whatsoever. That their judgment is based on the facts, evidence, and laws presented before them.
Okay.
So it has nothing to do with anything.
With politics at all. Okay. We must thank you so much.
And they must obey that order.
If I heard you for, we are hopeful that by Monday you would have your client with you, based on what you have expressed here.
Of course, sure. No doubt about it.
We wish you all the best.
God bless you.